Outlaw Lawyer.
Welcome back into the Outlaw Lawyers. Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm. They're the managing partners there, practicing attorneys here in North Carolina. I'm Morgan Patrick, consumer advocate. Our guests on set today, and again, if you're watching on our YouTube channel, we have Cassandra Nicholas and Taylor Scruggs-Smith, also attorneys at Whitaker and Hamer. Want to remind you too, if you have a legal situation you're facing and you've just got questions, well, I've got a number for you. You can call it and you can get some answers. Here it is, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call is about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to, again, questions@theoutlawlawyer.com. And I know we're going to get into the Texas law and Dodds versus Jackson's Women's Health.
Right. So we spent the last segment kind of detailing where we're at. So as a nation for the past 50 years, Roe v. Wade and its progeny, did I say that right? Progeny?
You did.
And its progeny is what's kind of governed the state of abortion in the U.S. And is anybody here over 50 years old? I'm not. Okay. Hey. There's no lawyer here over 50 years old.
I don't think you have to single him out like that.
I'm sorry. We can cut that out if we need to.
Big voice, just right over here. Lawyers.
So as long as most of us have been alive, this has been the rule of law. That was the point. That's all I was trying to do. Okay. And so possibly it might not be going forward. Right now it is. So I want to spend some time talking about the two matters before the court that have gotten us to this leak. Right. So we're slowly getting to the leak. But we've talked about this before on the show. But there was a Texas law. It had a name. What was it called?
We've always called it the Texas law.
We didn't have like another name?
Nah, we just said Texas law. Maybe we did. We talked about it a lot of times.
So Texas state came up with a law to discourage abortion, and it was kind of ingenious to a certain point. I'm personally not a fan of the type of law that they created because I can see it doing other things, but we'll talk about that. But they created a law where they wouldn't say abortion's illegal because they can't do that. Roe v. Wade says abortion is, in fact, very legal. And so Texas didn't want to make a law that was going to immediately get struck down. So what they did is they basically said, helping someone obtain an abortion is de facto illegal, right? So you had some civil penalties. So if, someone you knew drove someone to get an abortion, or the doctor that performed the abortion, or the nurse at the clinic, if you had personal knowledge that this happened, you could, in theory, sue them for up to $10,000, I think it was, in damages. And so the Texas state legislature came up with, enacted, the governor signed it. It's a law, and that has really discouraged, it's had the impact of discouraging women from seeking abortions in the state of Texas.
So basically, they deputize private citizens is how we describe it.
Right, and they achieved their goal, right? Their goal, I think, pretty blatantly was, we don't want anybody having abortions in the state of Texas, and this law pretty much did it. Variations of, there have been challenges to the Supreme Court over the past year, challenging the legality, the constitutionality of that law, and it hasn't survived as much as the Supreme Court has just kind of passed on those challenges, like sent it back to state court. Someone else should look at this. You don't have standing. Which I've always thought was very dangerous, because this model of law could just be used to limit any number of constitutional rights, gun ownership,
It's a way to circumvent constitutional rights.
And so I think it should have immediately just not lasted. Like, this should not be allowed, no matter how you feel about abortion. And that was kind of our opinion on that. So the Supreme Court's dealing with that. And then also the case that we're going to talk about, the case that is directly related to the leak, the Dodds v. Jackson Women's Health case. Who wants to tell us about that case?
So the law in that one kind of pretty much said, except in a medical emergency, if it's over 15 weeks, no abortions allowed.
Pretty straightforward.
Pretty straightforward. They said not, and interestingly enough, they said a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if they believe it's past 15 weeks into the pregnancy. And the only exception is medical emergency, which typically refers to the life of the mother.
Right.
So that's the one that got all the way up to the Supreme Court, because that was kind of a pretty blatant no abortion, not going with the typical trimester test that came up in Roe. So that's how we got to the Supreme Court.
And that case is out of Mississippi.
I was about to say Jackson, yeah, Mississippi. All right, so Mississippi knew this law under the current structure, under Roe v. Wade. This law is illegal, right? 15 weeks is inside of the first trimester. Is my math right? No.
But it's inside of the viability test that was.
Okay, so they knew this would be challenged. That was what I was trying to say. They knew they made this law. It probably wasn't going to pass legal muster. It was going to be challenged. And I think when we get to the leaked opinion, the Supreme Court kind of hints at that, like the Supreme Court's having to deflect these things.
And we've talked about this before on the show, is how several states have done this in varying degrees, basically put laws that were in violation of the Roe v. Wade standard. And I guess just whether it be trying to force the hand of whatever the reason was, it's something we've discussed in the past on the show as a recent kind of phenomenon.
And we haven't discussed trigger laws yet.
Yes.
What is a trigger law?
So trigger laws are most of the times laws that are ready to become actual law, like they're drafted, ready to be signed and passed once.
They've actually already been signed and passed. They're on the books in 13 states. So they're existing laws where they don't become effective until Roe v. Wade is overruled.
Right. We know abortion is legal, but the minute it's not legal, total ban, more or less, total ban.
And 13 states have that on the books right now. A few other states aren't making it a total ban, but it's highly limited, like this Mississippi law. So like a good number of states, probably almost half the states, have a law ready to go if Roe v. Wade gets overturned.
And so, like I said, we've been talking about this case for what seems like forever this year, just waiting to see. I don't remember what the official Outlaw Lawyer prediction was. I don't know what the official prediction was, but I'll tell you what I think I remember.
I'd say whenever the formal, actual, not draft opinion comes out, that's what our prediction was.
That's exactly what
That's
it is.
how we handle it, yeah.
Well, we have a conservative leaning court. I think it would have made sense to expect some sort of narrowing of Roe v. Wade.
I don't think we thought complete overturning.
Right.
I think we probably said that was unlikely to be the case.
This draft is really strong language. For me, at least, this is a really unexpected opinion.
Yeah, I think most people thought, we're 50 years in at this point, and that doesn't mean, and we'll talk more about that. It doesn't mean the court can't change course, because they can. But I think most of us thought that, okay, well, abortion rights are about to be limited more than some people probably would like.
Or clarified, however, just more of a standard.
And I kind of even envisioned a scenario where they give some things back to the states, right? They say, okay, abortion, Roe v. Wade is Roe v. Wade, but this is what we're going to let states do, So I did feel like we were going to have some sort of tightening of restrictions. And who knows, maybe that's where we end up. Because again, the leak is not a final document. And we can't stress that enough. So that's kind of where we were. We were all sitting here waiting for some sort of guidance from the Supreme Court on that Texas law and the Dodd's case. And I guess we still are waiting for some kind of final word. But in the meantime, the 90-some pages was dropped in our lap.
98 pages.
98 pages,
to be exact.
So that's dropped in our lap. So now we have at least an idea of what the court is thinking, an incomplete idea, a not final idea, but that is what has triggered the nonstop media coverage of this for the past day or two, and what I'm sure will be several more days and weeks of coverage. But up next, we'll actually get to the leaked opinion, what it says and what the court is thinking.
The Outlaw Lawyer, Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm, the power behind the program. I'm Morgan Patrick, consumer advocate. Our special guest in studio, and if you're watching on YouTube, you can see us. It's Cassandra Nicholas and also Taylor Scruggs-Smith, attorneys at Whitaker and Hamer. And again, what sparked this discussion, a draft of the U.S. Supreme Court opinion in the landmark abortion case of Dobbs v. Jackson's Women's Health Organization, leaked. Everyone's talking about it, so we are getting into that discussion today. If you've got a legal situation you're facing and you've got your own set of questions and you need some answers, I've got a phone number for you, 800-659-1186. That's 659-1186. And again, just leave your contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the program, and that's questions@theoutlawlawyer.com. We're back right after this.